The FRE Zone ACT 1995, Act 504, Part 1, Establishment of Free Zones Board, and related provisions. Section 1, Establishment of the Free Zones Authority. There is establishment by this Act a board to be known as the Free Zones Board, referred to in this Act as the Board. Section 2, The governing body of the authority. 1. The board shall consist of A chairman who shall be the Minister of Trade and Industry, and B 8 other persons, 4 of whom shall be appointed from the private sector. 2. The members of the board shall be appointed by the President in consultation with the Council of State and shall include at least 2 women. Section 3. Functions of the authority. The functions of the board are to A. Grant licenses to applicants under this Act. B. Assist applicants for licenses under this Act by providing services for obtaining other relevant licenses, permits, and facilities. C. Examine and recommend for approval agreements and treaties relating to the development and activities of the free zones. D. Monitor the activities, performance, and development of free zone developers and enterprises. E. Ensure compliance by free zone developers and enterprises of this Act and any other laws relevant to free zone activities. F. Register and keep records and data on the programs of developers, operators, and enterprises in free zones. G. Perform such other functions as are incidental to the foregoing. End of Part 1. Part 2. Establishment of free zones. Developers of free zones. Section 7. Declaration of free zones. 1. Subject to the Constitution and any other enactment in force relating to the acquisition of property, the President may, on the recommendation of the Board by notice, publish in the Commercial and Industrial Bulletin, declare A. Any area of land or building as a free zone. B. Any airport, riverport, seaport, or lakeport as a free port. 2. A declaration under subsection 1 of this section shall specify the area and the scope of activities in the free zone concerned. Section 8. Qualification of free zone developers. 1. No person shall A. Develop, B. Manage, or C. Develop and manage a free zone unless it is a body corporate registered under the Companies Act, Act 992, or a partnership registered under Private Partnership Act 1962, Act 152. 2. The body corporate or partnership shall be licensed to develop, manage, or develop and manage a free zone under this Act. Section 9. Rights and responsibilities of a free zone developer. 1. Subject to the Constitution, a free zone developer may for purpose of its activities A. Acquire land within the area declared in respect of it, and B. Lease or sublease real property it owns, has leased or has the right to use, sell or lease, and may sell or rent buildings to free zone enterprises. Section 9. Rights and responsibilities of a free zone developer. 1. It shall be the responsibility of a developer to A. Construct and maintain buildings, warehouses, factory, shells, and provide or contract other persons to provide or contract other persons to provide utilities or services such as water, electric power, telecommunications, and sewerage. B. Develop all other infrastructure necessary for the enhancement of the efficient and effective activities of the zone in accordance with any regulations made under this Act. C. Provide fencing and enclosures to separate the zone from the National Customs Territory and ensure security of the zone. D. Provide and contribute to the cost of facilities for such on-site customs services as shall be determined by the Customs, Excise and Preventive Services, CEPS. E. Undertake any investment or financial venture to facilitate and promote the development of the zone. And F. Submit, within such periods as the Board may direct, reports on development in the relevant zone to the Board. Section 10. Subcontracting by developers. A licensed developer may undertake or subcontractor management, control, and promotion of the free zone development in the declared area. 2. The developer shall apply for a license for any person to whom a subcontract has been given by it under subsection 1. 3. The application for a license for a subcontract shall be made to the board and shall be accompanied with the executed subcontract. Part 3. Free Zone Enterprises. 11. Subject to the provisions of this Act, any person may apply for a license to establish an enterprise in a free zone. 12. 1. No person shall carry on a trade, business, or industry within a free zone unless it is registered under A. The Companies Act, Act 992, or B. The Private Partnership Act 1962, Act 152, and is the holder of a license authorizing the carrying on of that trade, business, or industry under this Act, and license under Section 16 shall be referred to as a free zone enterprise. 2. A company or partnership qualified under subsection 1 and license under Section 16 shall be referred to as a free zone enterprise. 18. 1. A free zone enterprise shall have a right to produce any type of goods and services for export, but shall not produce any goods that are environmentally hazardous. 2. A free zone enterprise shall be free to A. Store, warehouse, pack, unpack and repack, divide, divide, group, break down, assemble, disassemble, bottle, rebottle, can, recan, decant, alter, sample, display, grade, test, classify, mark, manipulate, restore, join, transform, transit and transship, transfer, mount, refine, salvage, destroy, demolish, confect, label, reliable, finish, handle, mix, combine, clean, process and manufacture any foreign or domestic raw material, intermediate, semi-finished, or finished goods or components for export or re-export. B. Render and sell any type of information processing, computer, aided design, computer-aided printing and publishing, software, development marketing, and any other similar and related services. C. Render and sell financial, banking, insurance, commercial, advisory, repair and maintenance, professional training, and other services subject to all relevant laws and regulations for the time being in force. And D. Carry out any other activities relevant to its license as may be considered necessary by the board. 14. A free zone enterprise may change its production lines and process as often as it considers necessary, subject to prior approval of the board. Part 4. Licensing. 15. 1. An application for a license to develop, manage, or establish an enterprise in the free zone shall A. Be in writing, B. Be submitted to the Secretariat of the Board, C. Specify the zone to be developed, managed, or both of the trade, business, or industry for which the license is required, and D. Be accompanied with such information as the Board may require. 2. The Board shall cause response to be made to on application within 28 working days from the date of the receipt of the application. 16. 1. The Board may grant a license authorizing A. The development or management or both of a free zone, or E. The carrying on of a trade, business, or industry within the free zone. 2. No license shall be granted for the carrying on of A. The business of banking unless the applicant is also registered and licensed under the Banking Law 1989, PNDC 225, or F. The business of insurance unless the applicant is also registered under the Insurance Law 1989, PNDC 227. 3. A license is issued under this section shall be under the signature of the Chairman of the Board. 17. The Board may attach to a license such conditions as it thinks appropriate concerning employment skills, job, opportunities, and degree of export orientation. 18. 19. 1. The Board may revoke a license where it is satisfied that there has been a breach of condition attached to the license. 4. The Board may, upon the request of the licensee, vary at any time the conditions attached to the license. 5. Before revoking a license, the Board shall give not less than 14 working days' notice of its intentions to the licensee and shall consider any representations made to it by the licensee. 1. The Board shall establish and maintain a register of licenses granted under Section 16 of this Act. 2. There shall be entered in the register in respect of each license A. The name of the person to whom the license is granted, and B. The zone to be developed or managed, or both, or the trade, business, or industry to which the license relates. 3. The register shall be kept by the board and shall be open for inspection by the public, subject to such fee as the board may determine. 20. No licensee shall transfer a license issued in respect of it to any other person without the prior approval of the board. Part 5. Import and Export. Section 21. Non-application of import laws to free zones. The laws for the time being in force relating to the importation and exportation of goods and services other than consumer goods for commercial purposes shall not apply to A. The bringing of goods directly from a country outside Ghana into a free zone, or B. The dispatch of goods export out of a free zone to a country outside Ghana, except in so far as such laws are made applicable by regulations made under this Act. Section 22. Exemptions from taxes of imports into free zone areas. The imports of a free zone developer, subcontractor, or enterprise into a free zone or single factory zone shall be exempt from direct and indirect taxes and duties. Section 23. Sales in National Customs Territory. 1. The Minister may by legislative instrument authorize the sale of up to 30% of the annual production of goods and services of a free zone and single factory zone enterprise to the National Customs Territory. 2. Sales of goods from free zone enterprises or single factory zones to the National Customs Territory shall be considered as imports and shall be subject to the rules and regulations relating to imports into the National Customs Territory. 3. Damaged or rejected goods or samples may be sold by the free zones and single factory zones to the National Customs Territory, and such goods shall be considered as part of the 30% of annual production of the free zones and single factory zones authorized to be sold to the National Customs Territory, and as such shall be subject to the applicable duties and taxes. 4. An instrument issued under subsection 1 of this section shall provide penalties for contravention of any authority provided in it. Section 24. Sales from National Customs Territory to free zones. 1. Sales of goods and services by domestic enterprise from the National Customs Territory to enterprises in the free zone and single factory zone shall be considered as exports. 2. A domestic enterprise shall be eligible to benefit from the prevailing export incentives available to a national exporter and shall not require an export license for sale of any goods and services to enterprises in the free zone or single factory zone. 3. An enterprise in a free zone or single factory zone may purchase goods and services sold by a domestic enterprise with local currency obtained through conversion of foreign currency through the banks and any licensed foreign exchange bureau. Section 25. Entry into free zones by officers. 1. An authorized officer of any of the Revenue Services member of the police force or an officer authorized by the minister may, in the discharge of their official duties, at any time enter and inspect a free zone, buildings, aircraft, ships, boats, or vehicles in the free zone. 2. An officer exercising any power of entry or inspection shall on request produce his authorization. 3. Any person who prevents or obstructs an entry authorized by subsection 1 of this section or attempts to do so commits an offense and is liable on summary conviction to a fine not exceeding $1,000 or its equivalent in sades or imprisonment for a term not exceeding 6 months or to both. Section 26. Responsibility of Customs, Excise, and Preventive Service. 1. The Customs, Excise, and Preventive Service shall be responsible for control of zero-rated goods, A. within a free zone, B. in transit between two free zones, and C. in transit between a free zone and a point of entry into or exit out of Ghana. 2. The Minister, after consultation with the Minister responsible for Customs and Excise and the Commissioner of Customs, Excise, and Preventive Service, may be legislative instrument make regulations. A. Adopting or modifying for the purposes of this Act any of the regulations relating to customs operations. B. Governing the movement of persons, vehicles, or goods into and out of a free zone, from and out to other parts of the customs territory. C. Covering the keeping, storage, and handling of goods in free zones. D. Covering the keeping and preserving of accounts and records in a specified form in respect of goods in free zones. And E. Relating to the provision of security by bond or otherwise on goods in transit between free zones and points of entry and exit from and to other countries. Section 27. Missing due table goods. Where goods stored in a free zone are found to be missing without an acceptable explanation, the Commissioner may request a licensee to pay the duty on the goods at the rate in force at the time, in addition to any penalty which may be imposed by the Commissioner. Part 6. Incentives. Section 28. Tax concessions. 1. Free zone developers and enterprises granted licenses under this Act shall be exempted from the payment of income tax on profits for the first 10 years from the date of commencement of operation. 2. The income tax rate after 10 years shall not exceed a maximum of 8%. 3. A shareholder shall be exempted from the payment of withholding taxes on dividends arising out of free zone. Investments. Section 29. Investors. 1. A foreign investor may take and hold a maximum of 100% of the shares in any free zone enterprise. 2. A domestic investor may take and hold a maximum of 100% of the shares in any free zone enterprise. 3. Foreign and domestic investors shall have equal status within the export free zones. Section 30. Investment guarantees. Transfer of profits. Subject to this section, any enterprise in the free zone shall be guaranteed unconditional transfer through any authorized dealer bank in free convertible currency of A. Dividends or net profits attributable to the investment. B. Payments in respect of loan servicing, where a foreign loan has been obtained. C. Fees and charges in respect of any technology transfer agreement. And D. The remittance of proceeds, net of all taxes and other obligations in the event of sale or liquidation of the enterprise or any interest attributable to the investment. Section 31. Investment guarantees. Transfer of profits. 1. No enterprise in a free zone shall be nationalized or expropriated by the government, and no person who owns, whether wholly or in part, the capital of an enterprise shall be compelled by law to cede his interest in the capital to any other person. 2. There shall not be any acquisition of an enterprise to which this Act applies by the state unless the acquisition is in the national interest or for a public purpose and under a law which makes provision for A. Payment of fair and adequate compensation, and B. A right of access to the High Court for the determination of the investor's interest or right, and the amount of compensation to which he is entitled. 3. Any compensation payable under this section shall be paid, without any delay in authorization for its repatriation in convertible currency, where applicable, shall be issued. Section 32. Dispute settlement procedures. 1. Where a dispute arises between a licensee in a free zone and the government in respect of any activities in the free zone, all efforts shall be made through mutual discussion to reach an amicable settlement. 2. Any dispute between a licensee and the government in respect of any activities in a free zone which is not amicably settled through mutual discussions may be submitted at the option of the aggrieved party to arbitration as follows. A. In accordance with the rules of procedure for arbitration of the United Nations Commission of International Trade Law, or B. In the case of a foreign investor within the framework of any bilateral or multilateral agreement on investment protection to which the government and the country of which the investor is a national are parties, or C. In accordance with any other national or international machinery for the settlement of investment disputes agreed to by the parties. 3. Where in respect of any dispute there is disagreement between the license and the government as to the method of dispute settlement to be adopted, the choice of the license shall prevail. Section 33. Operation of foreign currency account. 1. Each free zone enterprise shall be permitted to operate a foreign currency account with banks in Ghana. 2. The terms and conditions under which the account shall be operated shall be set out in the license granted under Section 16 of this Act. 3. The central bank shall be consulted by the board on the terms and conditions referred to in subsection 2 of this section. Section 34. Employment in free zones. Free zone developers and enterprises shall be free to negotiate and establish contracts of employment with employees that include wage scales, minimum working hours, employee suspension and dismissal, settlement of disputes arising between employers and employees, and other such terms of employment as shall be consistent with ILO conventions on workers' rights and conditions of service. 2. Work and resident permits shall be required for any foreign national who wishes to live in Ghana and work in a free zone. 3. Application for work and resident permits for foreign employees of free zone enterprises shall be submitted to the board, which shall take the necessary action in consultation with the Immigration Service. 4. Subject to the existence of a double taxation agreement between the government of Ghana and the government of the foreign employee, the foreign employee shall be totally exempt from payment of income tax to the government of Ghana on income earned in the free zone during the period valid, except that he employee shall be liable of income tax in his home country. Section 35. Investment guarantees. Transfer of profits. 1. The board shall issue an identity card to all employees of licensed operators in a free zone. 2. A person who enters or leaves a free zone may be subject to inspection by any person authorized by the board to do so. 3. A person who obstructs or prevents any person authorized by the board in performance of his functions under subsection 2 of this section commits an offense and is liable on summary convicted to a fine not exceeding $500 or its equivalent cedis or to imprisonment for a term not exceeding 6 months or to both. End of Part 6. Section 43. Interpretation section. In this act, unless the context otherwise requires, free zone means an area or building declared as a free zone by publication in the Commercial and Industrial Bulletin and includes single factory zones, free port, free airport, free river or lake port,